for reminding me. Okay, so now we're recording. Thank you. As I was saying, so CLS, this is something that we want to keep at the forefront of our practice. It should inform everything that we do. So we want to say that up front, and we appreciate you listening. Okay. Okay, so a disclaimer. So as I said, we have Nick Johnson here with us, and he's a law student. Because he's a law student, he is not a lawyer and he doesn't have the ability to give legal advice. So if he were to be asked a question tonight, he can only answer it in a general way, and he can't give advice because he's not a lawyer, but he will be real soon. Okay, so what I thought we would start talking about is the Child, Youth, and Family Services Act. This is kind of the focal point of child protection law. This is the legislation or the piece of law that enables the court and enables parents and children's aid societies to do the things that they do to protect children and serve their best interests. In 2019, it was changed into the Child, Youth, and Family Services Act. It used to be the Child Family Services Act. The Child, Youth, and Family Services Act it has since, I think, really brought in the ability for parents and children's aid societies and interested parties to continue to protect and serve our children to the best of our ability for as long as we can, and flexible and common sense ways. So I think we're heading in the right direction. There still needs to be a lot of attention paid to the diversity of the children and families that we have in the province and across Canada. So hopefully, the Child, Youth, and Family Services Act will remain nimble to those realities. So as I said, the CYFSA is a piece of legislation in Ontario that governs child protection. But more importantly, in my mind, the Act makes sure that the children's aid societies need to take the least disruptive course of action if they're going to be involved in a family, in any case, right? But particularly in child protection court, we always need to be assessing whether it's the least disruptive course of action, because sometimes maybe an apprehension, as it used to be called, taking the child from the home and placing it in alternative care, maybe that's not the least disruptive course of action. Maybe other safeguards can be put in place to address whatever risk that they believe is happening. So it's our job as the kind of defending lawyers to really make sure that the least disruptive courses of action is being taken, not just any action, but the least disruptive, right? Because there's no doubt that apprehending and removing a child from a family is one of the most devastating and traumatic experiences that a family is going to have. And if we can minimize that trauma by taking the least disruptive course of action, that's fantastic. So that's always our goal. Furthermore, First Nation, Inuit, and Métis communities should be given the opportunity to provide child services in a manner that respects and recognizes the culture, traditions, and heritages. So it's not enough for us the CYFSA to just pay lip service by creating a statute that says we will do this and we will do that. We have to actually do the work, right? We have to make sure that we are not trying to involve ourselves or the state is involving itself in situations that it's not appropriate for them to intervene. And that, I'm not going to leave my personal opinion out, but we just did know that the government of Canada just announced $20 billion settlement for First Nations child welfare because of the trauma and harm that's been done historically. I'm not going to say whether that's enough or not, but hopefully that kind of thing continues to head in the right direction, because the idea that there's one catch-all solution for child welfare in Canada and in Ontario is just not, it's not a practical solution. It's not reality. Next slide, please. Thank you. So then I'm going to talk about just kind of briefly the child protection agencies in Toronto, in Ontario. So we have Children's Aid Societies and we have Child and Family Services, or CAS. You'll hear CAS bandied about lots. It's just that acronym. And so their role primarily is to investigate allegations or evidence that children under the age of 18 might be in need of protection. They obviously try to protect children where necessary. They can provide guidance, counseling, and other service to families for protecting children or preventing circumstances requiring the protection of children. They can provide care for children assigned or committed to society care. They can even supervise children in care, or they can arrange to place a child or children for adoption. Indigenous Child and Family Services agencies, and this is something that I hope we see more of, and that everybody supports, is where Indigenous Child and Family Services agencies can deliver culturally appropriate services for the safety and well-being of children and families in Indigenous communities and abroad. Again, this is the law acknowledging that there's hopefully not just one way to address a problem in a family, a problem with children, a problem with the child. And then lastly, we have the Ministry of Children, Community and Social Services. Some of you may have heard of this. They can provide financial and employment supports to low-income Ontarians. You've heard of Ontario Works. You've heard of other social assistance. They also help prevent high-risk youth from coming into conflict with the law and to improve their outcomes and reduce offending. If you want more information with respect to the Ministry of Children, Community and Social Services, you can just click on that link and they'll give you more information about the services that they provide. I'm not going to go into it more because we're focusing more on kind of the roadmap of child protection law. So what does it mean when a child is in need of protection? So this is the thing that, excuse me, CAS looks for. This is something that they have to establish for that agency to be able to remove a child from care or become involved with the family at a court level. They need to be able to establish that the child is in need of protection, and that there are no safeguards that could be put in place to mitigate that harm or that risk. A child can be removed to a place of safety, which is defined as a member of the child's family, extended family, or community. So their home would be a place of safety. However, you also have to establish, so it's not just that you have somebody out there that can possibly provide alternative care. You also need to have a place that society has assessed, or some other authority that has jurisdiction that has assessed that person's home, whether that be the family member or the extended family member or community member, and assess that that is a home that is safe for the child. So those two things need to be established by the Child Protection Agency to have a place of safety established. So CAS, in their efforts, will determine if the child is at a serious or immediate risk of harm. And if they do determine there is a risk, then they will remove the child. risks of harm can be established through the child being left alone, a pattern of the child being left alone, uncared for, or neglected. This could include physical harm or being at risk of harm from neglect, or sexual harm, emotional harm. It's not just not just physical harm. It's not just a child abuse. It can be neglect. It can be a pattern of emotional abuse. Again, the child having been abused or is likely to be abused, and the child sees abuse or violence between adults. So they're in the home and the parents are fighting, whether that be they're yelling at each other like cats and dogs, or they are physically fighting. Either way, the children are being exposed to emotional harm and perhaps physical harm. Note, though, that a child who is 16 or 17 must consent to be removed from the home. So the Child, Youth, and Family Services Act, when it came into effect, it expanded kind of the powers of CAS to continue helping children who otherwise aged out of the system. However, for the older children to be able to receive those services, they have to consent to it. CAS can't go in and pull a 16 or 17-year-old out of the home if they don't consent to it. Next slide, thank you. So this is a slide where I pass it to my caseworker, Nick Johnson. He'll do a great job. And then if we have any questions at the end, I'll see you on the other side. Okay, thanks a lot.
Thanks so much, Greg. So the other option that can happen is removal for the child's protection at birth. So the case in which this can happen is if there's significant concern of harm for your child or fears for your child's safety at the time of birth. Some of these concerns may include a serious drug or alcohol problem, the fact you're unhoused or have currently unsafe housing, or any other types of similar instability. So there's also something called duty to report. So a duty to report is for children aged 0 to 16, everybody, including members of the public and professionals who work closely with children and youth, whether that be teachers, social workers, daycare workers, etc., are required by law to report suspected cases of child abuse or neglect for children aged 0 to 16. So that means if they are suspecting that the child is being abused or neglected in any way, they are required to report it to CAS as soon as they come to this conclusion. For ages 16 to 17, everyone may report concerns pertaining to 16 or 17-year-old youth, but they are not required. The professional duty to report acknowledges that Child, Youth, and Family Services Act recognizes that people working closely with children and youth, so particularly like teachers, nurses, social workers, they have a special responsibility to report their suspicions. So that means they have a lower bar they have to meet before they are obligated to report suspected cases of abuse or neglect. So what happens when CAS does get involved if they do? So we have here's a flow chart that shows the order in which a action with CAS can go inside. So it starts with a referral received. And what a referral is just simply a complaint about somebody to CAS. So once they receive that referral, they'll determine if an investigation is required or not. If it is not, the action ends right there. You have no more contact with CAS. But if it is, they'll complete the investigation. And at the end of the investigation, if protective services are not required, the action ends there. You don't deal with CAS anymore. But if ongoing services are required, that means there's going to be a family service worker assigned. So there's 3 options that can happen from this point. The first is that the children remain in their home. And if that option is picked, then you will work with the family service worker to ensure their ongoing safety, and the file is then closed, and then that's the end of your involvement with CAS. The other option is that children can enter short-term foster care, which can be crown wardship, which is just the CAS apprehending your child. So what happens after crown wardship happens in short-term foster care is there can be adoption. And if adoption happens, there's permanency achieved and the file is closed. There can be legal custody, which is also permanency achieved, which closes the file, or long-term care with CAS. And if long-term care with CAS happens, they continue the care and support for that child until they're age 21. And if they enter short-term foster care, they can also be returned to the family. And then after that, it's the same process where long-term safety can be achieved. The file is then closed. And then the third option is that the children reside with a kinship family. So that can be close or extended family or another member of the community. So that can be in care or out of care. And after the kinship family is assessed, they can take full custody of the child, so whether that be an aunt, uncle, grandparent, etc., can have full custody of that child, or the child can be returned to the family. Moving on from there, so what happens if your child is removed by CAS? The first thing you should always do is call a lawyer. And as you're calling the lawyer, you should keep notes of everything that's happened. So that includes the date, the time, how your child acted during the time of removal, who was present, what was said, any details you can recall. The more detailed notes you can take about things involving the incident, the better, as it makes sure that there is nothing left to chance and that you know everything that will and can happen going forward. And then the next 5 days after the child is removed is a very important time period where one of 5 things can happen. 1, the child can be returned home. If the child's returned home, it's pretty straightforward. The child can be returned to the parent with custodial rights. Custodial rights can be granted to either the single parent or to both parents, depending on the situation. There can be a temporary care agreement. There can be a child protection court application, and the protection court application is CAS going to the courts and filing for long-term care of the child, or customary care, which is specifically care within an Indigenous community. So in the case your child is removed, are you able to see them? The short answer is you can ask the CAS worker assigned to your family about organizing visits with your child. But before you do so, you have to make sure you consult with a lawyer. You do not want to do anything with CAS without a lawyer if you can help it in this situation. And then the next steps, if CAS does apply to the court, the first option is that the case is dismissed, and then that's the end of the action. There can be a supervision order, which is essentially a fixed term that can vary in length, whether that's 4 months, 6 months, a year, etc., depending on the severity that CAS decides, where you have a list of conditions for the child to enter back into your care. There can be interim society care, which also operates on different increments of time, where the child will be in, whether that's a kinship home, a foster home, etc. So 4, 6, 8, 12, however long they decide that time. There's extended or permanent society care, which happens when they believe the child needs a sense of permanence in their life. So they don't want the child to be in a position where they are unsure what their future looks like. And if CAS has to do that, that means that they will be taking the child permanently, whether that's in a crown wardship or permanently in a kinship home. And there's also a custody order, which only happens if there's a threat of ongoing harm to the child. So what we have here is a list of resources. So the first one is Legal Aid Ontario. The second one is the Family Law Information Center. The third one is the Atlosa First Nations Inuit and Métis Family Services. And there's unbundled services or limited scope retainer lawyers, which can be found going on the Steps to Justice website, as well as some more information on what you should do there. So that concludes our presentation. Thank you so much for listening. Now we're going to open the floor for any questions you have for Greg. Thank you.
Thanks, Nick. Great job. And before we open it up for questions, I just wanted to add a couple of things that I thought of while Nick was talking. One, like I know lawyers are expensive, but usually in child protection law, you can get legal aid. But getting getting legal advice right away is paramount. I think because child protection law can move fast and it can be very confusing. And the CAS is not a knock on them, but they're an arm of the state, right? So they have all of the resources, all of the kind of wind at their back, and the parents don't. And the one way to kind of bridge that, or at least equalize that power imbalance, is to have an advocate who knows the law, knows the system, and knows how to protect your rights and advocate early and often. There's so many cases, unfortunately, that in CAS law that just kind of peter out because they've been in court so long. And part of that is, there are parents who truly struggle at addictions. It's a disease, and other very oppressive circumstances that may not be in their control at all. So it behooves us as lawyers and at the clinic to make sure that we are empowering parents to at least put their best foot forward whenever they can. I just think that's so important. I've seen too many times the first kind of month of child protection court is so confusing, so overwhelming, so traumatizing, and it moves very quick. The children's aid societies have to, if they apprehend or they remove a child to a place of safety, they have to bring it back to court in 5 days. That's the law. And oftentimes they bring it back to court in 5 days, and there's been no material served on the other party. So I would be duty counsel, say, I would be the free lawyer on site that a child protection parent could talk to. And many times they would come to me in an understandable panic saying, I'm in court today and I haven't even been served with any paperwork. That doesn't seem fair, right? Obviously. But unfortunately, that is something that can be done under the rules. And I think that's such an important part for us to be able to help, because that would be immediately discouraging for me if I was a parent and I went to court within 5 days, wanted to know what was going on, and they hadn't even served me with paperwork yet. And then there was going to be some kind of temporary order made that day, but they said to me, you can still get a lawyer and you can still fight. That would still be very discouraging and very disheartening. So it's so important for, again, to go back to at the beginning of my kind of diatribe, get legal advice. Call one of these resources called Legal Aid Ontario to get a legal aid certificate. Perhaps they have a certificate program, and if you financially qualify, or if you're on the bubble, even with a child protection case, you may very likely get a certificate. This is just obviously the kind of base level information, but we're doing this so that information's out there. And then if you want further information, you can contact a lawyer. You can look at steps to justice. If you have a case that you believe needs assistance from a lawyer, if you don't qualify for legal aid and get a certificate, maybe you give us a call and maybe we can help at Community Legal Services. But there's just such a, and I'm not saying that CAS strategizes it so there's a power imbalance. It's just a fact, right? They are an agency that has many workers and money. I know they don't have a lot of funding, but they have more funding than our clients do, more than the parents do. And so again, it behooves us to kind of equalize that as much as possible and make sure that everybody's on a level playing field. Thanks for allowing me to go on that little jaunt. Okay, so I see, is it Javiera?
Yes. Hi. I'm a family preservation advocate in my community. I'm located in Sarnia, Ontario, so just an hour away from London.
Okay.
But I do work with folks in London. I have a question regarding this slide about removal at birth.
About the what?
This slide about removal of a child at birth.
Okay.
How does that work legally, considering that CAS can't really get involved while the person is pregnant and birth alerts are not really a thing anymore in Ontario?
Mm-hmm.
Like, how does really CAS know or get involved at birth? I mean, like, I know how it happens, but like, how, like, what are the legalities around that?
Yeah, that's a good question. I mean, it usually comes through the same way as, a referral, a complaint about, you know, uh, I have a neighbor, they're pregnant, and I've seen them out front smoking marijuana, and then maybe the society becomes involved with the mom to monitor. Like, I mean, I think the mom can say, no, I don't want to work with you.
Yeah, like it is in your legal right actually to call the police and even file a complaint with the Child Family Services Review
Right.
Board if CAS gets involved during pregnancy.
Right.
Like if you tell them to go away and they don't, like they can only interact with you if you agree to volunteer services. So that's my question here. Like,
Yeah. Well, ends up happening usually? So if they do say, so the mother in this circumstance, for example, she says, everything's fine, take off CAS, I don't need your help. You don't have any right to kind of be involved in my life. And they may very well go hands off. But then, once the child is born, um, depending on their evidence, they may take some kind of action. But where this kind of scenario is usually prevalent is when there is a parent who has had multiple children, and so they have history
okay,
with the given society, and so they will. And sometimes they may even be in a ongoing case involving another child, and then they will become pregnant during that case. And then CAS will say, well, we can't formally become involved with you, but we would like you to work with us voluntarily. And then if you don't work with us voluntarily, well, then they kind of use that sort of Damocles over their head to say, okay, well, if you don't work with us voluntarily, then we're probably going to have to take more aggressive action. Right.
Which is not right.
Yeah.
okay, that makes sense. Thank you for
Yeah.
explaining that. Yeah, that's been basically my experience as well, but I was just wondering about the legality of it, but that makes sense with a call being made and then basically just waiting around the time
Yeah.
that the child is, yeah. So even though alerts are illegal, or I mean, not allowed anymore, or whatever,
Yeah.
they still really happen through surveillance.
Yeah, I just can't imagine you'd see it ever with a new parent.
Okay,
That
okay.
does happen.
Yeah. Any other questions? Sorry, I gotta pop open the chat.
Yeah. My question is, in the beginning, you mentioned contemporary stewards. Can you explain that to me?
A temporary steward.
Yeah, you mentioned it in the beginning, the contemporary stewards.
Okay.
Under the Haudenosaunee part.
Oh, I don't think, did it say temporary?
Contemporary.
Oh, can you go back to the, Nick, can you go back to the, no, you mean to the land acknowledgement, right?
Yeah.
Okay.
I just want to.
Contemporary, yeah, contemporary, whom we recognize as a steward, like now, you're still the steward is a confusing word for sure.
Yeah.
Yeah. But what we're saying is that you're still a not your, but Indigenous people are still the contributors and what I would say the owners of this land, right? A contemporary, meaning now, right? Not historical, now.
Because you also mentioned birth alerts. That still happens today, but a lot of times they don't give us those 5 days notice. They give us the notice after the fact.
Okay.
And it still happens today, like more or less in the South, because
Okay.
it's less, I don't know what word to use, but less ignorance, I don't know, or less cultural.
Sensitivity, yeah,
cultural sensitivity or cultural awareness of the Part 4 of the Child and Family Services Act. And then, by the time, and they end up fighting with us. Because I'm up north,
okay,
Children's Aid is Peo Catano. And, and then when we have babies being born in the South, they've already taken them into care. So I had I was on the phone when a child was being apprehended at the hospital, and there was nothing that I could do to help stop it, mitigate or whatever, because the workers didn't want to listen to me. Even though I verbally had a request from the grandmother, she can take the baby home, and she said yes. And I would follow up with her. But that didn't happen. They said, I had a court order, here's the paper. Meanwhile, they didn't even have a court order to begin with. They just lied through their teeth to take the child to care. So then we end up fighting. I end up doing a lot of my research as well when it comes to the Child and Family Services Act, because that's a pretty big act. Anyway, but looking at the Child and Family Services of Part 4, I really had to dissect that section to kind of fit to the First Nations, Métis, Inuit, children. So it still happens today, but at the same time, they don't hold responsibility for not following the Part 4 section.
right. Yeah. That sounds really disappointing, to say the least. They shouldn't be placing, especially, if you're in Northern Ontario and they're placing, and correct me if I'm wrong, but they're placing in Southern Ontario, right? Is that what you said?
Yeah, because
I don't even get that. I mean, let alone you should be looking to, to keep the child or children in the community.
and
Yeah.
The other fact too, that this Child and Family Services Act changes on a whim. Feels like
Okay.
it changes on a whim, because it changes according to situations that happen within a Child and Family Services pertaining to First Nation, Métis, and Inuit children. So back in 2000, that section was really small. It used to be Part 10 at one point, but it only had 2 paragraphs. But as the years, grow, and through history within the last 20 years, that part, now it's Part 4, and then there's a little more added to it. So still, the ignorance lies within the agencies further south that they don't follow that. So even though, because Fort Albany First Nation is really huge, if we want to look at the residential school era.
Yeah.
A lot of kids, a lot of families came through here, and a lot of them have been adopted out. We don't know where they've been adopted out, because according to the $20 billion settlement, we have a lot of work to do in Fort Albany First Nation pertaining to child welfare.
Yeah.
And how do each of them get compensation? So I'm trying to do my legwork and to help support families that have been through that system. But a lot of them have died in the process as well. Then who's going to advocate for the dead?
Yeah.
So and at the same time, that birth alert still, grinds my gear when I'm also trying to be respectful at the same time, because of the social determinants of health with First Nation, Métis, Inuit families. Because we were set up to fail still today from the get-go, how to parent our own children. That's where the 94 calls to action came about.
Mhm.
And also this FNMI Act that was released back in January 1st, 2020. And I'm still fighting. I'm still fighting for these children even today. And I don't know what can I do, because if I'm looking at my map of area of scope of working within child welfare system, there's 50 of them, and I'm working with 30 of them. I'm affiliated with 30 of the child welfare agencies in Ontario, and I'm trying not to drown at the same time, because I'm it gets overloading with reporting, follow-ups, making sure we don't lose kids to society. And how do I do that to make that, to make an echo statement to say these are our children and we want them back?
Yeah. I mean, one thing I 100% agree. what a lot of work to be done. And that's why I said up top, you know, my personal opinion that I'll leave that for another day. But a lot of work to be done. And it doesn't seem to be happening fast enough. And that's why I keep telling my students, let's keep the momentum up. Let's keep the, because it seems like, a culture at large, we have these, these things that we all rise up for, and then a week later we're done, right? And so to answer your question, it's continual work. Yeah, you're right. That's a good point. There isn't a lot of work to be done. It's an oppressive system that needs abolishing. Let's not diminish the pain the Indigenous families have suffered from this system. 100%. Yes, a very good point. And I appreciate you raising that. I don't have the solution for sure. I wish I did. All I know is that we trying our best to work within this system and trying to have more public legal education like this, so that we can continue to tell people that this is a problem that needs to be fixed, and we need to stop talking about it and just do it. I wish I had more specific information to kind of address that issue, but I mean, I can't imagine the amount of work that you're doing, and it's a great thing, but I am also sure it's very, very exhausting.
The other part too is that we're just being notified now, 10 years later, by some of the children's aid down south. We're just being notified now,
Yeah.
after having kids in care for 10 years later. The only reason why we're being notified now is because of adoption. They want to
Okay.
adopt our children. But at the same time, I'm like, I've been in this field, actually in child welfare field for the last 3 years, but I've been working with child welfare system for the last 22 years. So I'm at a different advocacy and keeping our children closer to home, at least. And and the
100%.
agency finally admitted, that yes, we had these children for the last 10 years, but that was the big turning point, where they said, but I said, wait a minute, there is no but in this. They said, your agency there should be no ignorance within your agency with the child welfare reform system that's happening, the redesigning of child welfare. I said, how does your agency work with that? Especially when it comes to the act that was presented back in 2020, the new act that came out.
Sorry, how does our agency work?
Yeah, when it comes to the new act.
So at our agency at large, I can tell you that, so I started at CLS in May of 2021. And when I got here, we did not do child protection work. So I got here, and maybe within 6 months or so, I made a push for us to start doing child protection work. So our policy regarding child protection work, even generally, is very new. What as my role as review counsel here at CLS is I can also triage and kind of use my discretion with respect to what kind of cases we take. And I would like to see more CAS cases, and I'd like to see more CAS cases with families that have been marginalized by society, so that we can advocate for them. And like I said, for lack of a better phrase at this point, really level that imbalance, that power imbalance that just exists when you first set your foot in the agency's building, or you first talk to a child protection worker. That power imbalance is there, and I am an advocate in trying to make sure that there isn't a power imbalance, and it's an uphill battle. And as you know well, Jocelyn, it sounds like you've been fighting the good and hard fight for a long time. And I can't understand that. I won't pretend to understand it. But it's very heartening to hear, and again, momentum to keep this conversation alive, I think, is so important.
The other piece too of looking for help, or if anybody has any ideas they can like help me with, is that when it comes to special needs of our children, like like Jordan River Anderson, you know, he died because of a system failure due to his health and his family. So we're actually, I'm going through the same thing with another child of ours who's been in care since birth, but at the same time we are made to feel that we're incapable of looking after our own. So, you know, it's been a trying time for me to be able to advocate and work with the parents because of the systemic racism that's been happening. And also, you know, how do we move, for us to move above that as well, to be able to work within our own communities to say, you know what, we can do this. But at the same time, I'm looking for avenues on how to support this child. And some of our children are actually in London as well. I haven't had time to be able to visit all of these communities in the South to be able to say what's going on. London is one of them. I'm slowly trying to make my way out that way, and also Toronto South area. So, so special needs is the one I'm really trying hard to focus on, because we don't have a lot of services for advocacy. How can I do that?
I just, Nick, if you could just come on the screen, I'm going to put you on the spot here.
Yeah.
Do you know of resources that we could provide that Maureen Bulbrook might have, you know, with respect to, you know, really trying to, in certain regions, providing, you know, focused assistance, focused help, because I know Maureen just got a pretty good position up there, right?
Yeah.
I came to one of your resources, the CPRI building, or just the Child Parent Resource Institute. I came there to drop off a child, but we need more. I don't know how to do that.
I don't know any off the top of my head, but I can definitely ask Maureen.
Yes. How about, so I'm going to put my email in the chat. If anybody wants some further resources, especially with, you know, what we're talking about here, please email me, and Nick and I will contact our resources and see if we can connect some people to really have a focused effort. Okay. Heath, I see. Sorry, Heath, I see you have your hand up.
Yeah, thank you, sir. Well, thank you very much for this very informative and useful presentation. Thank you, Greg. Thank you, Nick. That was really very helpful. I've got an interesting comment actually in one of the feedback forms. Someone is asking about if we can release the slides. So if I may ask you to confirm that this session will be tomorrow on the YouTube channel of Western Law, as well as it will be on the Rights and Responsibilities Awareness Initiative website too. So I think this could be a reference later on, and this could be an access to the slides and to the presentation as well.
Yeah, correct. Thanks for that, Heath. So now I'm just looking through. Yes, just the slide, not the chat. Yeah. Just looking through these chat questions. Question from Miranda V. Good question. So essentially the question is, does every child receive a children's lawyer when they're involved with CAS? Depending on their ages, is if a child is not old enough to kind of articulate their make sure, sorry, I was just reading the chat, it came up. You want to make sure that the children are old enough to articulate perhaps their wishes and preferences, or about who they want to live with, or how much time they want to spend with a particular parent. But also any, say there are clinical issues, you know, perhaps maybe there's behavioral problems at school with the children. Maybe they're acting out violently. Maybe they're expressing wishes and preferences in a way that sounds like an adult is influencing them, things like that. If children or a child is too young, then the OCL is likely not appropriate. You're just not going to get something you can't articulate. They can't articulate a cogent response, right? You don't know if their thoughts about whether they want to live with mom or dad or grandma or whatever parent is actually their true feelings. The children's lawyer, the Office of the Children's Lawyer also plays two roles. There's the lawyer. You can have a lawyer appointed, and the lawyer is usually appointed to express the children's wishes and preferences about parenting time, the parenting schedule. That's what their role is. Whereas you can also have appointed a clinical investigator, which is a social worker or mental health professional who is going to look at those clinical issues and can also see, you know, is there influence going on? Is there alienation going on? Excuse me. Are there signs readily ascertainable by the social worker that these children are being abused, or that they are parentified, which means, you know, are they looking after a younger sibling because they always have to take care of the child? Those kind of things, if the evidence is there that those things might be present, then the children's lawyer will be appointed. In child protection law, if the child is old enough, they will provide an Office of the Children's Lawyer. Though in child protection law, that's more readily appointed than and easily appointed than in family law. I think because the stakes are higher in child protection law, because the risks are higher, the risk of harm is there. So the children need an advocate. If you, like, if it is a court scenario, which you would have to be if you're getting the Office of the Children's Lawyer involved, or it's child protection mediation, then the OCL is automatically appointed. But if, at least in my experience, if you're not in court and you're not in child protection mediation, those the OCL isn't appropriate in that circumstance. I mean, you could perhaps apply for it, but more often than not, we get the Office of the Children's Lawyer through an order from the court. So that would be my answer to that. Definitely not every child receives a children's lawyer involved with CAS. Okay.
Is there, oh, sorry. Is
Yeah, go
there a
ahead.
legal avenue to advocate for a child to get a children's lawyer?
Is there an avenue for that?
Yeah, to advocate for a child to get a children's lawyer?
Yeah, certainly. Certainly. I know so like outside of court or inside, like outside of court or in court?
Don't children lawyers don't get involved unless it's in court?
I'm sorry, I didn't hear you.
Like, I feel, what isn't one of the requirements for a children's lawyer for it to be in court? They won't take cases out of court.
No, I've had cases where we've just been in child protection mediation. So Children's Aid Society has decided that they're not in court, but they can mediate perhaps a kind of impasse between the family and CAS. They will get an office of the children's lawyer, given if the child is old enough to give kind of instructions to their lawyer.
Okay.
A lawyer will be appointed.
Okay, awesome.
Okay.
Any avenue to advocate though? Is there like an official channel way that parents could follow? Or mostly just get guidance from specific lawyer about the case?
Yeah, a specific lawyer.
Okay,
I mean, I've never had a scenario where like a non-lawyer made a pitch for the OCL. But what I know is you make enough noise, somebody's going to do something. I know if I had a uninterested party or a third party, say to me, we need an office of the children's lawyer for this child. We need it, and it was a regular email, phone call to me. I'm going to try to find a way to do it. I find in child protection law, the squeakiest wheel gets grease. You gotta be regular with your kind of your concerns, your complaints, your why aren't things happening fast enough? Because even if things don't happen fast enough, you have a paper trail, so to speak, of, hey, I was on you guys every week about this and you did nothing.
okay, wonderful, thank you. That's great advice, thanks.
Yeah, no problem. Okay. I hope I answered your question, Miranda. It was a bit meandering, but not every child just automatically gets a children's lawyer. I see you raise your hand, Jocelyn. Just a sec. I'm just going to go to Maria. Her chat question here. Yeah, good question about the birth alerts. And I see there were some responses that they officially ended then in June last year, but birth alerts are still happening up north. So you see that, Javiera?
All the time.
Yeah.
Like the situation that was actually mentioned in the chat, that folks are like coerced into agreeing to voluntary services and then they don't really have a way out of it. I myself have had 2 personal experiences with CAS, both of them really like not real calls. And the second time I was like very informed about my rights when my child was 4, and I like was able to say, I'm not engaging with you. You can get a court order if you would like to talk to me or come in my home, but my child is not in safety. My child is not in harm's way. My child is safe. He's, provided with everything he needs, and you guys already have confirmed that. So blah, 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 blah. So like I myself have helped clients that are pregnant, for example, pass custody to a grandparent to ensure that they like have like the stability needed before transferring custody back to them, that they have continued to parent and care for the child. But like there's like lots of avenues that can be taken around it. But I personally have had a lot of experiences, or as well as folks being kind of coerced into giving up the baby to get the child that they have in care, or being told you can keep the baby but give up the parental rights to the child that's in care. So yeah.
Yeah, that is an unfortunate reality that still exists, and it needs to stop. What I tell my clients, and I would say to you folks, is that I wouldn't be signing any consent without legal advice. But I know what can happen is, workers can say, like, you need to sign this consent so I can get your parenting time going, or something like that. But you don't know what you're really signing to. But because again, that kind of like first month of things happen so quickly, you know, you may sign consents that you're not, you know, 100% accurate in what you're signing. And that's not a criticism against you at all. Not at all. It's just the idea that that can happen. It's like when somebody gets arrested in criminal law. Everybody I think knows, you know, the rights are read about your right to remain silent and so forth. I know criminal lawyers that say to their clients all the time, don't say anything until you speak to me. But in situations of removal to a place of safety, everything happens so quick. And, you know, I think there should be kind of that same principle where you don't have to say anything to them until you speak to a lawyer to try to figure out what's happening here. And that is something that needs to change, and is the primary reason why I want to do this PLE, because of how fast things happen to families, and they understandably have no idea what happened. So hopefully, if nothing else, we can take away from today, you know, contact a lawyer. You don't have to sign anything until you're talking to a lawyer. Make sure you understand what the kind of what the roadmap of how things are going to go are. What are your rights? Okay. I'm just going to check the chat here before I go to Jocelyn. Okay. Alrighty. I just want to make sure that, because I see a couple people just worried about the chat being recorded. Heath, I see you're still here. Do you know,
Yes.
like,
Yeah, yes, I can confirm that when we publish the session, the chat will not be included.
good to hear. Thank you for that.
By all means, yeah, by all means. We do care about people's privacy, and we do understand that some issues might be a little bit sensitive, so we have the full consideration for this.
Thank you for that. Jocelyn, I wanted to make sure I got back to you.
I'm sitting here kind of laughing at myself because I totally forgot what I wanted to say, but because you know when my mind starts going and I forgot to write it down.
Mhm.
One of the things that that kind of weighs heavily too is that when a parent dies in the process, like a parent, like a Fort Albany First Nation member parent dies. So the question now that, you know, we've been advocating to have these children registered under the Fort Albany First Nation, you know, have them go through the process, from birth live birth statements to getting all their IDs. But throughout that process, a parent dies. So now, how do we keep that momentum going when another parent is not from Fort Albany?
Is the other parent Indigenous?
Yes, but they're not, or non-Indigenous. Either, it could be both, whether they're Indigenous from another community or non-Indigenous.
Okay. I know what at least so I used to practice in St. Thomas, 20 minutes south of here or so. Like, we would make sure that there was a culturally appropriate placement no matter what. And that's what should be happening up north. It doesn't sound like that's happening.
No.
I would, I don't know, do you do you know the CAS lawyers in your community?
Yeah, well, for our band has a First Nation lawyer,
Okay,
but we deal with like I said, the 30 other agencies. And the default in our area, and for us, I feel like through discrimination is that just because an Indigenous parent dies and the non-Indigenous parent all of a sudden gets all the attention, whereas they're not following the lead, considering that we were going through the process of registering these children, but now that's not the case.
I would, and this case is in court.
No, not
No.
yet. No,
Hmm. Perhaps my
it's not.
optimism is misplaced, but like if it went to court, I mean, the court,
Can we go to court though, if that were the case?
if the society believed that the child was still at risk of harm, and there was no way to kind of mitigate that harm, to lessen that harm, then they would bring it to court. But if they believe that the child is safe in this other parent's care, then perhaps they don't need to go to court. But I mean,
Yeah, the
I-
non-Indigenous families are not returning the children
okay.
because the parent had died, the Indigenous parent died.
Is the question if the band can advocate for the child to have access to Indigenous heritage instead of a parent? Like, is that the question?
Yeah, the child is Indigenous, but they're not registered yet.
Okay, and it would be not the parent advocating, but the band to get the child registered.
That's what we're working on, but they're not giving the child back.
They're not giving the child what?
They're not giving the child back to the grandparent who looked after these kids last 3 to 5 years. And all of a sudden, out of the woodwork, the non-Indigenous parent comes into play, and all of a sudden the children go for a visit and then they're gone. All of a sudden, all the favor goes to the non-Indigenous family.
Well, yeah, I would speak to a lawyer and get specific advice as to how to address that in your area. Because I mean, like what I would be doing is, like, if you talk to me and you came to me with that specific problem, I would be writing CAS and I would be saying, I hear that this is happening, and without any regard, without any regard to maintaining this Indigenous connection, this very important part of this child's life, and you're just ignoring it, that can't happen. And then I would be saying, if that's your plan, then perhaps maybe not even child protection court. There needs to be kind of a family law claim going. But what the question would be is, who are going to be, like, are there specific community members who are going to also be caregivers? Right. One, there should be an order made that that the remaining parent needs to maintain the cultural connections, needs to be doing whatever possible to make sure that the child remains in the community and so forth. That's what my first step would be. But if you called me as a lawyer, I would be writing a hectoring letter to CAS saying, I hear this is happening, needs to stop. Pick a new plan. If you don't, perhaps this needs to go to court. But what I do know is that they're still going to, if the parent, or if the Indigenous parent has passed away and there's a remaining parent, that parent by default will have this primary care until, CAS perhaps decides too much of a risk. But that's the default. It doesn't mean it can't be changed through court or through negotiation. But I think it goes back to, I would just be, and I know you're likely doing this, is, phone calls, letters, emails. This can't happen. This can't happen. It's a shame that it's happening. But I would be saying, you need to address this. However you can maintain the cultural connections, maintain this child in this community, you need to do it. And I would, and if they didn't do it on consent voluntarily, I would be threatening some kind of court action.
I also want to mention that, like it was mentioned, to give the child back, that it's always, if it's safe for a parent to have the child, it's always going to be the parent who is going to get the child first, not a grandparent. But regardless of who the child is under custody or care of, the child themselves as a person has a legal right to their Indigenous heritage. So like the focus should be on advocating for the child to have access to their Indigenous heritage, whether that's by a means of registration of, in their clan, a band, or you know what I mean? Instead
well
of
said.
like to the grandmother, because until there are concerns of safety, that won't be an appropriate route of getting the child the access to their indigeneity. So yeah.
Yeah, very good information. Thank you. I would just keep making noise. And I know you've been doing that. But it takes all of us, and you've been doing the work. And we need to, like Javiera said, we need to, it's a system that perhaps needs to be uprooted again. I saw your hand go up again. This will be the last question. I know we had about an hour, and we've gone past that. So, Jocelyn, why don't she ask your question? And I've given you my email. If any of you have any additional questions, be they general, I can answer them. And I definitely want to Nick and I to follow up to give you further resources if possible. Okay. So Jocelyn, did you have one more question?
No, I was giving a thumbs up to
Okay.
the last person who made a comment.
Okay. All right, thanks, folks. That was awesome. I really liked it. There was a lot of feedback. The most feedback I think we've had, dealing with very prevalent issues, and we'll continue to do our damnedest. Okay. Jocelyn provided some great information, and so did Javiera, and some great questions in the chat from people. So it's great to see that. We're going to be doing more of these. It won't be child removal next time, but have a look out for that. We'll be talking. For anybody that missed it, I just see a message that you missed half of it. There will be a recording in the Rights and Responsibility Awareness Institute YouTube page, and also the Community Legal Services YouTube page or Western Laws page. Okay. So you can start signing out now. Yes, 100%. Jocelyn, yeah.
Is it possible I can make a remark or ask a question?
Yeah.
Okay, so my spirit name is Goddess Fight Wedding Woman. My legal name is Melissa, but I'm an activist in the city of Toronto that actually support women of domestic, Indigenous, and all other types and nationalities that combat systemic racism and also cultural insensitivity, again, and domestic abuse of drugs and violence, what have you. And it's quite interesting, the type of things that we face, or I see families face in the system, especially with CAS, because I'm a survivor of domestic and child abuse myself. Is there more information that I can share on my Instagram platform for parents who are afraid to speak out against domestic abuse because of the lack of attention from the system itself, whereas people are reporting it to the police and the police are turning it against them, that they can reach out to you guys. I can tag you guys in a post on Instagram if you guys have an Instagram page.
Very good question. And thank you for that. So what we can do is, I don't know if you saw my email in the chat. If you email me and repeat your request, Nick and I are gonna look for as many appropriate resources that we can find for those of you who are interested. Because I mean that's what we're also here for. If we can't assist in some manner, we also want to be able to direct people in the right direction.
Awesome, because there's families that are afraid to even speak out because of the logistics of the home, right? Of the, again, murder rates, of domestic abuse, right?
Yeah.
So there's I'm able to work with different grassroots and organizations in the city of Toronto to sort of actually, instead of using the system, but first bring them to safety first, right? So it'd be nice to build I guess a survival kit where we can share within different beauty supplies and different companies and things that women would actually go to and are expressing their thoughts, or you can see the physical pain, because not everybody is able to go to a shelter. Not everybody's able,
Very good
like
point.
you said, 7 times to leave a domestic situation, and and sometimes the system is not in for our best favor, right? So definitely, I'm going to send you an email. I do have your email, and hopefully we can team up and provide other supports in and around Ontario. Thank you for this workshop.
Yeah, that's great to hear, and I look forward to your email.
McGuire.
Okay. All right. Okay. Okay. All righty. I'll start removing people from the chat. Okay. You folks have a good night.